Good afternoon, everyone, and welcome to H-1B and PERM Compliance for Human Resources, our annual webinar dedicated to HR and what you need to do to make sure that you're in compliance with all the rules associated with H-1B season, and as well as the labor certification application process. I'm joined by Cliff Rosenthal, and he will be doing the PERM section on the second half, and I will be doing the H-1B section up front. So let's begin by, thank you, by the way, for joining. And I also want to say that, it's a pleasure to put these on, and we really appreciate any feedback you have. So at the end of the program, please, if you don't mind, take a minute to fill out one of the questionnaires, just not certifying that you've watched it, but reviewing how Cliff and I did, and if you enjoyed the program, or if you have any suggestions for making it even better. As it says in big red letters on the bottom of the screen, this video presentation does not constitute legal advice and is for information purposes only. If you have a case-specific question, please contact us after the webinar. And if you want any further information about any of the slides that you're going to see or things that we're going to talk about, feel free to contact us afterwards, and we're happy to give you more information. We love, talking about this kind of stuff, and I call it my immigration nerd impulse. But here we go. If I can figure out how to move the slide. There you go. All right. So at the very outset of the whole process for H-1Bs, the very first thing a company has to do is file an LCA with the Department of Labor, and there's a bunch of things you have to do before even that. They're listed here. The ones in red at the bottom are the things that H-1B dependent employers and willful violators must do in addition to everything else. But the 5 main ones is, determine whether or not you are dependent or willful violator. Provide notice to all similarly situated workers in the geographic area where in the work sites where you're going to be employing that person. Certify that there's no strike or lockout or work stoppage, and give the H-1B worker the same working conditions as everyone else who's employed in that area in that similar position. And the most important one that I'm going to talk about today, because it's come up a lot lately, and I wanted to touch on this point, is that the employer certifies they will pay the H-1B employee the required wage, and the required wage is the greater of either the actual wage or the prevailing wage. And also will offer benefits and eligibility for benefits to the H-1B employee as they do for similarly situated workers in the U.S. So, with that in mind, I thought I'd get into a little bit more about what actual wage is, what prevailing wage is, and get into the nuts and bolts of the benefits. I think that might be beneficial, especially for HR individuals. So the actual wage is really, in a way to think about it, the wage that the employer has paid or will pay other employees that are in the same occupation, and the same occupation means that their duties and tasks of their specific position are essentially the same or substantially the same as the H-1B's position. At the place of employment, and that means the work site specifically in the LCA. So if there's multiple work sites, you have to include all those individuals at all the work sites and take the greater. With substantially similar experience and qualifications as the H-1B, that is another kicker, because some people wonder whether or not that's the only thing that must be taken into consideration. In fact, it's not. You also have to take into consideration, or rather you can take into consideration the individual's education, their job responsibilities and functions, because that can vary from position to position, the specialized knowledge specifically held by that individual, and you can take into account also other legitimate business factors, i.e. things that are, it's reasonable to say that they're necessary for the position, and they're based on some, grounding principle or, rules or standards. Those kinds of things, if there's a company-wide policy for establishing actual wage, then you include it. If it's something that's on paper, or if it's not on paper, maybe consider putting it on paper. That applies across the board to all individuals. That is something that can be helpful to back up a claim that an actual wage is what you say it is. And also, for the record, if there's no other employees existing in that worksite location, or will exist, in the reasonable foreseeable future at that place of employment, then the actual wage is the wage paid to the H-1B non-immigrant. So you can set the actual wage if it's the first time that you're actually going to be approaching it. Prevailing wage, on the other hand, is usually the result of conducting a survey or finding and obtaining an already ran survey of the wages received by individuals in that geographic location. So that's different from the place of employment, worksite specific. This is more geographic area. This is the metropolitan statistical area, depending on which survey you use. It could also be the county, if there is no metropolitan area around there. There's many different ways and many different surveys. There's many different ways to calculate the prevailing wage. It could be the median or the mean. The one utilized by the Department of Labor, rather the one that the Department of Labor holds out as their not necessarily sponsored but provided survey from the OFLC Online Data Center, is the average. And it combines 4 different wage levels. So whenever it does the survey for people in occupations in that geographic area, it takes into account the average wage received for entry levels, for qualified, experienced, and fully competent. So that's levels 1, 2, 3, and 4. You can take a look at those links afterwards. You'll receive a copy of these slides, and they'll be available on our website. But you can take a look at those links and visit the Department of Labor site, click around, and see what you find, because it can be very helpful to know in advance, even before you approach, say, the immigration attorney, to get this ball rolling, the ballpark of the salary that will be minimally required for prevailing wage side. For actual wage, that's something you have to do on your own, but the prevailing wage, if you use an external survey, it's already provided for you. Any immigration attorney would provide that anyway, but if you know where to look, you can already take a look and see if you agree. Also, a note at the bottom for individuals who will be working for colleges and universities, nonprofits associated with those colleges and universities, or certain types of research organizations, including government, etc., then the prevailing wage survey should only include the wages of those workers who also work at one of those types of organizations. This is referred to as Acquia wages, and notably the OFLC Online Data Center provides a drop-down for either all industries, which can be used for everyone but those types of organizations, or higher education or Acquia wages, which is specific to what I just said. And then the next part about, wrong way. And the next part about this is this one attestation that's key is to offer benefits and eligibility for benefits to the H-1B worker, as you do for the similarly situated workers in the U.S. So, for example, the benefits such as disability insurance or retirement savings plans, number of vacation and holidays, health insurance, life insurance, etc., bonuses, those packages need to be offered to the H-1B on the same basis and in the same way as they're offered to the U.S. workers. So if you offer certain benefit packages to full-time workers, then for any full-time H-1B workers that are similar, you have to offer the same package or packages. If they are part-time to part-time, that's how it matches up, professional staff to professional staff, so you don't have to offer a same benefit package you would to, say, a CEO or executive as you do maybe someone in a lower position. But the key for this is that it's all must be done in good faith. If you offer one of the benefit packages to the H-1B foreign national, and they accept, then they have to receive those benefits. Some benefits may be credited towards the satisfaction of the ultimate requirement that the employer pay the required wage rate. So, for example, any bonuses that are non-contingent or any payments or taxed benefits, that would mean including specifically anything that would be reported as earnings with the IRS, then those types of benefits can be used to meet that criteria. Notably, too, as a little aside, certain multinational corporations who maybe did not use or utilize the L for their worker for whatever reason, and they have them on an H-1B in the U.S., but they're still on the payroll of or rather they're still under the employ of the foreign company. If they're still receiving the benefit package associated with their foreign position, as long as it is, substantially the same, rather that it's no less advantageous to what is offered to the relevant U.S. workers. And there's a number of other requirements. So if you're in this position, reach out to an immigration attorney. But if that's the case, then that H-1B employee can keep their home country benefits, and the U.S. employer does not have to make that offer. A lot of things have to be done ahead of time. There's 8 or 9 specific requirements for this. So it's on your radar now. So if it applies to you, please give us a call. So once you have calculated the prevailing wage rate, or more appropriately, that you found the survey and you've done your homework on the actual wage rate, then you must compare them, and whichever is higher is the required wage rate. So that is the bottom baseline that you can pay that individual in H-1B status. And so that is what is going to be reported on your I-129 minimum. If they get paid higher than that in the future, that's fine. They cannot be paid lower than that. If they get paid higher than that in the future, and I might touch on this later, and it's associated with some other change, then we can get into the details on what's required there. But if it's simply just a raise with no necessary changes in the position or job duties, then there's no harm, no foul. So there's lots of things written about specifically what is required for the wage. I think I would also like to talk and touch on specifically the last bullet point here for authorized deductions. So any deduction that reduces, any authorized reduction rather, that reduces the H-1B's wage below that wage rate is not permissible. An authorized deduction is permissible, even if it goes below the required wage rate. Authorized deductions are ones that are, they have to meet one of 3 basic criteria. If it's required by law, say income tax, FICA, etc., those may permissibly reduce the wage rate below the required wage. If there's some deduction that's authorized by, say, a collective bargaining agreement, either union dues, contribution to premium for health insurance policy, coverage for all employees, savings or retirement funds, contributions for lawful plans, those types of things, because they are included in the collective bargaining agreement, would be authorized deductions. And then also a deduction that meets a whole slew of pre-agreed upon conditions, say that something is for the benefit of the employee. So this touches on the benefits package, but is not necessarily directly linked with it because it can be different. So if you have a written agreement with that employee ahead of time, that it's not going to be a reimbursement for an otherwise business expense with that employee, and it cannot be any reimbursement of any H-1B fees or something similar. But it's principally for the benefit of the employee. Say maybe housing, as long as that housing is not, a job requirement that they be housed on premise or something similar. But anything like that can be used, but the valuation is important of whatever that benefit is. So the amount cannot exceed the fair market value or the actual cost, whichever is lower. So you can't artificially inflate, say, some valuation of a benefit given to the employee, like housing. All of this, again, and keep in mind, good faith is what's required for all of this for compliance purposes. The Department of Labor understands to a very limited extent that these are very complex regulations and requirements. But as long as the employer is doing everything on the up and up and nothing is quote-unquote shady, then there's at least some defense there. Speaking of the H-1B fees, all costs and fees should be paid by the employer. Now this means the legal fees associated with the H-1B, the government filing fees, etc. Anything along those lines. Now, specifically, what's required by law is any of those attorney's fees associated with the preparing and filing and work ahead of time to make sure everything's in compliance with the LCA. There's a gray area, of course, as most areas of the law, about where it crosses the line. So that's why we say it should be covered by the employer. Splitting the fees, not splitting the fees. There's too many split hairs. The most cautious approach is to have the employer cover all of the fees. But the government filing fees mandated by the government to be paid by the employer are that acquia fee of the $750 or $1,500, depending on the size of the employer, 26 above, below, respective, and then the $500 fraud prevention fee. The $325 fee, therefore, may be paid by either party, but again, we say that it should be paid by the employer just for safety's sake, playing the most conservative. But then the, if they do pay that $325, or if they do pay some other portion, say the premium processing fee or something like that, then it must not reduce, that will be subtracted from whatever they do receive that year or during that relevant period, if that's all they've worked, and it can't reduce their wage below that required wage. So that kind of gives you an overview of what is and what is not acceptable. Now, another fun part of H-1B is keeping and maintaining your public disclosure files. We usually get questions about this in October with the start of the start date of all the cap subject H-1Bs for the year, as well as the extensions from 3 years prior, assuming the employees have not had any changes. So this is a good time to always review your public disclosure files. You have to make them available within 1 working day after submitting the LCA. They have to be maintained for at least a year after either the withdrawal of the LCA or whenever the employee no longer works under that LCA. So another requirement, whenever an employee is no longer working under an LCA, for that employer, for example, the employer has to submit a letter to USCIS as soon as possible. They say immediately, as soon as it is actually possible to do so, indicating that the employee is no longer with the company and no longer employed under the LCA. Then you can withdraw the LCA, and then you have 1 year to maintain that public access file. In addition to the public access file or public disclosure file, synonymous, there's also some non-public documents that have to be kept, which I'll get to in a minute. But just to quickly review an overview, and then I'll get into some more of the specifics with some examples of things that you can do for your public disclosure file. The original signed and certified LCA. So after the attorney sends you the certified LCA or you receive it from the Department of Labor, you print the 2 copies, sign 2 original copies. One goes to the employee on or before the day they start working, and the other goes straight into the public disclosure file. You'll need a memo stating how the wage rate for the employee and the system for setting the actual wage for all employees in that same or similar position was arrived upon. Prevailing wage info and source documentation. Interestingly, in the public disclosure file, a copy of the determination, or rather the survey used itself, is not technically required, but it makes sense to include it. I don't see any reason why you wouldn't, because all that information is otherwise included in there. All that's really required is a memo summarizing it. But in the non-public documents, you have to keep the actual survey or info. So there's no harm in keeping them together. They are. It's not person specific. So in the public, it does not breach any confidentiality issues with your employee. The evidence satisfying the notice requirements. So, either that notice was given to, or rather that you posted 2 notices in 2 conspicuous locations for 10 consecutive business days in the places of employment listed in the LCA, with a signed dated memo confirming that this has been done, or you've sent the appropriate notice to the collective bargaining representative or union when it was, and it has to occur before the LCA was submitted to the to the Department of Labor. The summary of the benefits packages that are offered to all employees in the same or similar position, as we talked about previously. And if there's been a change in corporate structure since this LCA has been certified and filed with USCIS, and no amendment has been filed or no new petition has been filed, you have to keep in the public disclosure file the certain documentation confirming that the predecessor entity and the current entity have successfully transferred all liabilities and obligations under the LCA to the new entity. It doesn't matter if the FEIN changes or not, but you need to document it either way in this declaration. We in particular like to include these kinds of declarations, all the information that's required in the public access file for a change of corporate structure. We like to include in one declaration by the person who's responsible for maintaining them that talks about everything that's required, including the actual wage determination, the base pay determinations, the numbers of LCAs for that position that have been transferred, the FEIN information, and all the appropriate statements, all in one document for the public disclosure file. In the non-public disclosure file for a change in corporate structure, which I am kind of jumping ahead of myself since it's a later slide, but just to talk about it now. For a change in corporate structure, the non-public documents must have a list of all the H-1Bs that were transferred to the new entity. So non-public has the full master list of all the H-1Bs, so their names, the corresponding LCA numbers, etc., that were transferred. So it can be cross-referenced by the DOL in the event of an investigation, where the public disclosure file just has to have this declaration confirming for each of the positions, LCAs, the numbers of the LCA. So it's not unique, it's not identifiable specifically to the employee. That's just a heads up, And then if the company, during one of their attestations at the beginning to determine if they're H-1B dependent or not, if they use what's called a single employer determination, then you have to include a list of all the corporate entities associated with that determination. This is specifically for companies who, for H-1B dependency purposes, the ratio of H-1B employees to all employees is what matters. And so if you're using the single employer method, which can utilize your subsidiaries or your sometimes affiliates, depending on where, then you have to list all those entities there for purposes of the public disclosure file. And then, obviously, if there are H-1B dependent or willful violator, the additional record-keeping requirements, which I'm not going to get into today. For the non-public documents, like I alluded to, this must be maintained, with the exception of payroll records, must be maintained for 1 year or more beyond the last date. So you can keep your non-public documents and your public disclosure documents for each of those LCAs for the same amount of time, with the exception of the payroll records. payroll records in particular must be maintained for 3 years from the date that they were created. This specific regulation allows USCIS, if necessary, to, during an extension, request pay records for the entire period of previous H-1B validity. Just so happens. Not necessarily intentional, probably intentional, but either way, that's what the rules are. So a copy of the H-1B petition is filed with USCIS is in the non-public documents. So this will be employee-specific. It'll have their information about where they attended school, what their grades were in some instances, in addition to some potentially information that the company doesn't necessarily want public about itself. In particular, the gross and net for closely held companies, or etc. Those payroll records, the memo that states the wage rate for, or rather how they set the actual wage. It's funny, this is also required in the public disclosure file. For the public disclosure file too, we typically, whenever we provide examples or templates for this for people to utilize for their public disclosure files, you can combine the actual wage system description with and in the same memo as the particular method used in this case and what the result was. And I'll show you an example of that in a coming slide. So then here's where you'll also have that signed and dated memo confirming the date that the LCA was given to that second signed LCA was given to the H-1B employee on or before the first day she began working. A documentation of the fringe benefits, including what was offered to the H-1B employee, and then what was eventually selected or declined, and then what's actually provided, and then also showing the home country benefits package, if it's applicable for that H-1B employee, so that the Department of Labor and Investigation will be able to ensure that everything's on the up and up. As you can see, a lot of this is things that you maintain, which is similar to PERM, which Cliff will talk about in a moment, but these are things that you must maintain and produce in the event of an investigation, similar to the PERM, where you have to produce all these things in the event of an audit. But for H-1B purposes, as we've been seeing, there's been an increasing frequency of investigations, be they based in a complaint or not. So all the public disclosure file documents and non-public documents are fair game for the FDNS inspectors. Therefore, they have to be maintained, and it's very important that there's one person, or at least, not one person fully devoted to this, but that it's an essential part of record-keeping requirements for the HR departments. So I'm not going to get into the weeds on the rest of those non-public documents, that we already touched on the corporate structure and H-1B dependent employers, willful violators. So here's a sample of, say, the actual wage determination. Specifically, this is one for a company and how they came upon it. All information is blacked out that is identifiable. But in this, since this would be in the public disclosure file anyway, the position information is public knowledge. The location is public knowledge. The LCA number is public knowledge. So all these things are things that are lawfully able to be taken into consideration when determining the actual wage. If you have any questions about specific ways you can keep your public disclosure file up to date, or you want any templates of anything for the non-public file, let us know. Here is a sample of the documentation of the benefits offered to the foreign national. As you can see, it has the LCA number there. So this is something that would not be personally identifiable for the person publicly, but is able to, in the event of an investigation, be able to be linked with the non-public documents that are associated with it. In this case, all U.S. workers in that particular position or in same or similar positions in those offices of the company were offered medical, dental, and vision. Similarly, then, that H-1B employee was offered medical, dental, and vision. If there's any difference in things that are offered, you have to explain why. Generally, there won't be or shouldn't be, unless there's something, say, regarding home country benefits, like I touched on before. And that was that the certain multinational companies can avail themselves of those home country benefits and exempt from the offering of similar benefits requirement. Then we also have a last example here that I'll share with you today, so I don't take up too much time, of the confirmation of the prevailing wage determination. So like I mentioned before, that actual copy of the survey is not necessary, but is sufficient. This memo explaining it attached to that survey is, the most conservative approach and the best way to proceed. It's an independent authoritative source. You could attach this to, say, for example, the OFLC Online Data Center determination for that county or metropolitan statistical area, and then you're all set. If you have another specific way that you have determined the prevailing wage, for example, if you've done it through a collective bargaining agreement, please let us know if you need a specific type of template or sample to use. And I spoke briefly about different types of changes, and when after an LCA is already certified and the H-1B is approved and they've been working in that position, but what if something else changes? We said that if they get more money, great, but it's not a change in their job duties, so they don't have to amend anything. There's nothing that needs to be filed. However, some things like, for example, let me just think off the top of my head, if things change that are more substantial, for example, if their job duties change as such that it would fall into a different occupation, that may be material enough to warrant a new petition, a new LCA and a new petition. The reason is the wage requirement would likely change if it's a new occupational category. If the duties change slightly and it's not necessarily out of the same occupation but maybe requires the application of a different area of specialized knowledge. So, maybe a mechanical engineer starts doing more electrical engineering or sales engineering type duties that would maybe require a degree in a different subspecialty. Arguably, and I'm happy to argue with you about it, that would require a new petition. But, individual cases should be discussed individually. This is just more of a broad overview. One in particular change that, usually does require something to be amended or filed with USCIS is that if the location of employment changes. So if the area of employment specified in the LCA, rather say, is in New York City, and the place of employment is going to move to somewhere else outside of that area, with no new LCA being filed yet, a new petition would likely be required. Other changes that would warrant this would be, say, if the company headquarters changes locations, that may trigger a need to file an amended petition as well as LCA. Whenever these types of things happen, whenever just an LCA is required, that's still important because the wage requirement would change. Because every year in July, the Department of Labor, in particular, publishes new prevailing wages. So if you're dependent upon the OFLC Online Data Center and their determinations for what the required wage, or rather, the prevailing wages are, then every time you either amend an LCA or have to file an amended petition based on that, you may have to be upping the salary if there's no actual wage higher than the prevailing wage. All right, so I feel like I'm getting into the weeds a little bit on this, so I'm going to just briefly say some types of things that are minor and would not require a new amended petition. If an employer just changes its name, all else being equal, there's no need to amend. If the employer changes ownership, unless a new LCA has to be filed, then there's no need to move forward. We talked about changes in corporate structure and the types of things that would be needed. As long as the new owner undertakes all responsibilities, liabilities associated with and under that certified LCA, and a few other things are also included, then no new LCA or no new petition is required. Moving on. So we're kind of going through the life cycle of the H-1B, as you can see, things that are pre-filing, things that are filing timely related, starting, maintaining changes, etc. Now termination. So the Family Medical Leave Act does not consider, leave under the Family Medical Leave Act does not terminate the H-1B relationship with an employer. Any leave that is requested by the employee, and it would have to be requested by the employee in writing in that regard, would not be considered benching. There's no benching allowed, for example, in the H-1B context. You can't place them on no work, no pay holding area. But if they request specific types of leave that would be covered under some other form of state or federal law, like the Family Medical Leave Act in some cases, then it can be okay. We always just say to employers, get those requests for it in writing, either via email or signed statement. Email is usually sufficient. So with termination, the employer, like I said, has to notify USCIS immediately. The employer is also liable for wages under the LCA until that LCA is withdrawn. So not only do you have a requirement and an obligation to inform USCIS as soon as possible, you're also, within your best interest so that you're not liable for continuously paying someone who's no longer working there. That has been brought up, in lawsuits where people have been successful in getting wages back for failure to pay because the employer never withdrew the LCA. If you want some specific guidance on that, feel free to contact us. So I think that kind of covers termination in a nutshell. I think I'm going to do some of the asides just very quickly. E3 and H-1B1. So specialty occupation workers in classifications extremely similar to, if not substantially similar to, or essentially the same as, the H-1B for all other purposes include the E3 for Australians. We have a free trade agreement with Australia / they joined the Coalition of the Willing last decade. The H-1B1 for citizens and nationals of Chile and Singapore. They each have a set number. There's an H-1B1 cap per fiscal year, similar to the H-1B, but I've never seen those reached in recent years. As a matter of fact, I don't even think that USCIS has published a count of those in recent years. Nonetheless, you sometimes will encounter these individuals who have these don't even need to file with USCIS. They can apply for the visa directly from one of the Australian consulates, or their home country consulates or embassies. And all the same rules apply except the H-1B dependent employer willful violator provisions, which we skipped over anyway today. The change in corporate structure provisions, which allow individuals to continue working for the new successor entity, or the entity that purchased the old entity, or resurrected it from some other form of perhaps bankruptcy, for example. Those E3 and H-1B1 employees don't get the benefit of continuously working. But what's nice about those is they can go abroad, get the new visa, come back, and start working immediately for that new entity upon entrance in the new, back in E3 status pursuant to an offer of employment with that employer. They would need a new LCA in order to apply for the new visa in Chile, Singapore, Australia, or wherever they are home whether they consider home as long as they're a national of one of those countries with the appropriate category. The short-term placement rule does not apply to E3s or H-1B1s either. This briefly, describes what the short-term placement rule is, but kind of backing up from that and giving a little broader picture, in general, H-1Bs, H-1B1s, and E3s can't work at any work site that's not listed in an LCA unless a new LCA is first filed and certified. There's two exceptions to this. The first one is when that site is not considered a work site. There's lots of, like I keep saying, in the weeds types of things to say when a work site is not a work site, or rather when a work location is not a work site. Things that would be like going to somewhere for employee development activities, trainings or seminars. That doesn't in necessity become a work site just because they're physically there during normal work hours. But if you have any questions about what is and is not a work site, let us know. And then the second exception to the short-term, or excuse me, to the rule that you cannot work at a work site unless there's an LCA filed and certified there, is the short-term placement rule, but that's for H-1Bs only. So while this doesn't apply to H-1B1s and E3s, I will say it briefly. An H-1B can be sent to a new work site not covered by an LCA to work in that occupation for a maximum of 30 days each year. So in the aggregate, 30 days. Or up to 60 days each year if more conditions are met. Primarily for those first 30 days, as long as everything else is okay and the employer is following all the rules and has not violated anything of the LCA underlying the actual worksite location, the home worksite location, that's great. But for the 60 days, from 30 to 60, they also have to be maintaining an office or workstation at the permanent worksite. So there has to be something there, where they consider home more than 50% of the time. They spend a substantial amount of time at that worksite, permanent worksite, in the 1-year period, and they have a U.S. residence or place of abode located in the area of the permanent worksite. So, it wouldn't be fair to say that they, if it's not realistic, if they have their home and they consider their home Chicago, but their primary worksite is California, as listed in the LCA, they don't have a residence or place of abode there, they don't get more than 30 days of coverage outside of Chicago. But if they do have their primary home in California instead, they would get up to 60 for other locations. So I know that that's maybe trailing off of the slides a bit, but I just wanted to touch on that for a minute. Another important thing to consider if you file your own LCAs or you're working with an attorney who's not familiar with these subset type categories, the LCAs must be filed as E3 Australia, H-1B1 Chile, H-1B1 Singapore, as opposed to just H-1B. A lot of consulates and embassies will otherwise deny them. USCIS does deny them. So, heads up. So I have some information here for those interested in H-1B dependent employers and rule for violator provisions. Whenever I spoke about the single employer calculation, here's a general bullet point of the different numbers or ratios, rather, of H-1Bs to full-time equivalent employees that need to be taken into consideration. The magic number here is if you are on the cusp of H-1B dependency, the determination has to be made at the time, or rather the relevant determination for LCA purposes is made before filing. So, if you are H-1B dependent or not, really only matters whenever you're filing that LCA. The magic number to consider is if you have 50 full-time equivalent employees versus 51 or more, because the ratio changes. As you can see some examples down there. You drop down to 51 to 75, for example. You can't have more than 11 existing H-1Bs on the payroll. So it kind of dips down, and so that's just a silly provision of the law, but nonetheless one that employers in those circumstances need to be aware of. Of course, there are some exceptions for willful violators for specific types of individuals that they're going to hire who would otherwise be exempt from this calculation. But if you have any questions about that, let us know. You have to indicate on the LCA if you are in fact H-1B dependent. Well, here we go. Here's some more information about those exempt employees. If they're being paid at or above $60,000, or they have at least a master's degree or equivalent in the specialty, then they would be considered exempt, and the employer would not be subject to additional attestations related to an LCA specifically for an exempt employee. As you saw in previous slides, some of those additional attestations that are a negative consequence for employers associated with that status are having to recruit U.S. workers. Whenever someone unfamiliar with the H-1B process says, well, I don't want to have to recruit U.S. workers for this position, it's just an H-1B, and it's like, well, you don't have to unless you are, in fact, H-1B dependent or a willful violator. So heads up on that again. And here's another note about corporate restructuring. Like we said, we like to do one template type of declaration for the public disclosure file that includes all this important information. The non-public documents that correspond with it must have that master list of all the H-1Bs transferred, so that in the event of investigation, you can pull out both of those types of files and say, look, here's all of the public ones, and here's the master list that corresponds with them. We did everything we needed to do. We did our due diligence during that restructuring so that immediately upon the successor entity taking over payroll responsibilities and employment responsibilities, everything was already in the files as they needed to be. Therefore, there's no dramatic fees or penalties that we have to suffer. So I kept talking about also these investigations. The Fraud Detection and National Security Directorate, FDNS, it's a USCIS, but it's also authorized in a way and associated with the Department of Labor, which otherwise would be normally doing these types of investigations. Just to give you a kind of background, I don't have the fiscal year 2012 numbers yet, but for fiscal year 2011, 15,648 unannounced workplace site visits from USCIS FDNS occurred on H-1B employers. That was during fiscal year 2011, so October 1st, 2010 to September 30th, 2011. There's lots of things that you can do to prepare for these. You can think about it like this. There's 65,000 regular cap per year and 85,000 including the master's cap. So you can see that, the 15,500 per year, and it's increasing. We know it's increasing. It's anecdotal, sure, because I don't have the numbers in front of me, but I know of many more of my clients that are receiving these types of visits than in previous years. You can see that there's a large percentage of your H-1Bs. You should assume therefore, that you're going to get one at some point during the course lifespan of employing an H-1B employee, and or during that last year after they stop working there, whenever that may be, when you still have to maintain these files. I think that you can read these slides yourselves, but I think I'm going to also go through ways that you can prepare for a site visit, and more importantly, what to do during the site visit. So, I think that creating and implementing an action plan is key. We like to recommend one individual, the same individual responsible for the public disclosure files, be designated as the primary contact for the site visits from FDNS. Maybe one person is the backup in case they're out. That way, the chain of command, reception or security or whoever the first contact personnel is aware of who needs to be notified in the event of a random site visit. The person who does the public disclosure files is probably the best because they're the one who have knowledge of and access to all those files. They'd be able to easily get them for whoever else may be required. The next thing to do would be to call your, or rather, we'll get to that in a minute. Ensure the accuracy and consistency of shared online and other public information. So if your company has a website, then you need to make sure that it is up to date with all the relevant information about your company for the sole purpose, if not for business reasons, but for the purpose for FDNS. Whenever you submit an I-129, USCIS takes the position that you have waived all rights to privacy with regard to employing that H-1B employee, so that they will inspect your website. They will, they can come to the building and take photographs of the exterior, posted placards, any signs, to verify the existence of the physical premises, but also the electronic existence of the company. So, for example, a company that is a website design company that does not have a website may be problematic. If you don't, you understand what I'm saying. So, it has to be realistic. These officers really they're contractors most of the time, but they really do want to see and verify that everything is actually as you say it is in the petition. And I'll say this now, but I'll come back to it in a minute, to periodically review your site visit action plan and your public disclosure files to make sure that they are up and running. October is a great time to do it since you have a whole new crew of H-1B employees who have started in that status. So, if you need help or assistance with that process, of course we are here. Now, during the site visit, some helpful tips, what I was going to say, but stop. Contact your attorney as soon as possible. FDNS officers will generally not reschedule a site visit to allow counsel to be present. They should allow them to be present, at least telephonically, if nothing else, for the interview portions of any site visit. Interview portions mean that they can, and most likely will, ask to speak with the beneficiary supervisor, and the person who's responsible for maintaining all these records. Maybe someone in payroll who has the pay records that need to be maintained for 3 years. But if that stuff's already in the non-public file maintained by the same person who's otherwise responsible for all this, it'll be easily accessible, and you can minimize the number of people that need to be involved in this show. Determine whether it's a FDNS visit rather than, say, an ICE visit, Immigration and Customs Enforcement, or Department of Labor wage and hour. There's other means by which the government can do site inspections on employers to make sure that they're compliant, most of which are the result of a complaint, but nonetheless, don't assume that they're FDNS whenever they may in fact be wage and hour, or they may in fact be ICE. Just make sure to ask. Excuse me. You can also tell maybe if they don't have like a badge or they're not extremely talkative about it. FDNS is generally at current related to H-1B site visits, but also some L1 visits, some EB-1-3 visits, and also some marriage visits. And this is off topic, but maybe some marriage-based cases FDNS would look into. I would say whoever is the frontline person, be it the person responsible for running this visit or the reception or security, would request photo ID and a business card from the site inspector. They have to have that on them. You want to take down key information, including the date, the location of the work site visited, the agent's name, their badge number, the agency from which they represent, the telephone, email, specific reason for visit if they actually say it, and the receipt number for the petition in question. They'll usually be coming on one particular petition, not generally an employer who has, say, 50. And just say, let's see what you have. They will more likely than not, rather, have at least one, if not 2 or 3, specific petitions that they're going to be wanting to request information about and talk to. By now, your attorney should either be on the phone or physically present. Just due to the nature and size of this country, most likely on the phone. But you're going to be continuing to take detailed notes during any interview in the event any follow-up is necessary, but also because whenever the FDNS officer either declines to let an attorney come, even though they should allow them to be present or on the phone, you may have to relay this information back to an attorney after the fact. So even if it's not you that's taking the notes, have someone there to take all these notes, so that we can be fully kept abreast of the situation. If you're unsure of an answer to a question from an officer, and this is something that H-1B petitioners can also benefit from thinking about, is don't guess the answer. Ask to respond. I'm sorry, officer, I don't have that information directly in front of me. If you'd allow me to respond at a later date, I'd be happy to do that. So I can, the answer, or why do you need more time? Well, I want to verify the answer is actually correct instead of just, making something up. If I don't remember, I don't remember. I just need to pull it up. Under no circumstance, though, should you guess or provide inaccurate information. It's much harder after the fact, say if they do a notice of intent to revoke after a site visit gone horribly wrong, to fight these kind of things than it is to just clear them up at the outset by saying, I'm sorry, I don't have that right now, but I'd be happy to provide that for you. Or, if the worst case, say, the person who's responsible for keeping all these records is out sick, so is the backup person, and nobody knows where the public disclosure file documents are, or nobody knows where these pay records are. Maybe the computer crashed. I'm sorry, officer, can we reschedule this for another time? I'm so sorry about this inconvenience, etc. Make it photocopies of any documents, any and all documents that are given to the site inspector, just for A, for your records, and B, for your attorney's records. Sometimes we've had instances of people in payroll maybe being the individual talking to an FDNS site visit inspector, and the person who's in charge of the files didn't even know that the FDNS was there. Payroll gave them some internal, like a screenshot printout of the internal pay system, which had a lot of the random inaccurate numbers associated on the screen that really were not used, but nonetheless were populated with useless or otherwise internal information that was misinterpreted by USCIS, FDNS, and resulted in a horrible notice of intent to revoke. So thankfully, we had a copy of that dated printout, and were able to deal with it appropriately ahead of time, within the short amount of time we have to respond to one of those. And last but not least, cooperate. You do not want to be seen as obstructing justice. You don't want to be seen as rude in general. You also just want to be, you can say, would you mind waiting in this conference room, please? And they say, no, I want to walk around and talk to the beneficiary now. You can say, or rather, if you say no, they may take that as you did not allow them to perform their duties and or you're obstructing justice, etc. So have someone with that person all the time. Just cooperate. Can I get you anything to drink? Can I get you a glass of water? Can I get you some coffee while you're waiting in the conference room for so-and-so from HR to come down, etc. But nonetheless, cooperate, whatever they need. Yes, officer, let me look in my file and see if I can get that for you. Let me just check in the public disclosure file. 1 second, please. Or, oh, I think I have that, that document is in the non-public document file for this person. Let me just go check on that. Or, oh, officer, actually our LCA indicated that we were going to keep this public disclosure file at the worksite location, not at our company headquarters. I'd be happy to contact that office for you and let them know that you'd be coming, or I'd be happy to have that scanned over to us, etc. Nonetheless, make their life easier. So I've taken up a whole lot of time for this presentation, but nonetheless, I will now turn it over to my colleague and mentor, Senior Attorney Cliff Rosenthal.
Thank you very much, JJ. So just very quickly in the time that we have left, we just want to go through some of the enforcement aspects of the PERM program. We've dealt with the temporary, the non-immigrant visas, the H-1Bs mainly, and the E-3s, and now we're going to look really at what kind of enforcement actions, sanctions that Department of Labor and the government provides in the PERM context. So there are just three aspects that I want to touch on today. First is a very brief introduction into what PERM is and the criteria of PERM. This is not meant to be a PERM webinar. It's not going to go into the details, the strategies, but just touch on the basics for those people that aren't familiar with them, that will allow them to understand what the PERM employer enforcement strategies of the government, and particularly the Department of Labor. The second, the second aspect is what are the employer's obligations in terms of PERM, and then the third is going to be a direct look at what the government, especially the Department of Labor, is using in order to strategize its PERM enforcement program. So let's get going. Okay, so really what is PERM? Stands for Program Electronic Review Management, not permanent, the P, as most people think, and it really refers to what we call labor certification. It really refers to what we call as stage 1 of the immigrant visa in the employment-based category for most applicants, most employees go through this PERM process, and it's the first stage of the green card process in the employment-based context. The first stage is the stage conducted by the Department of Labor, and the USCIS and Department of State, do touch on them, especially in the enforcement part, but really this is a program that is managed almost entirely by the Department of Labor. So the real basis of the PERM is that the employer will conduct a good faith test of the labor market by means of recruitment and some other activities. Basically, it will advertise for the position, and will try to, at least at the end of the process, they will try to attest to the Department of Labor that there were not any able, willing, or available American workers who meet what we call the minimum qualifications for the position. Not the average qualifications, not the best qualifications, but the absolute minimum qualifications. Then what will happen is after this recruitment period, the qualifications of all applicants are then reviewed by the employer, and then if based on that review, if no American workers are found qualified, then the PERM is filed with the Department of Labor. It's done online, and really what it is, it's a series of attestations that certain recruitment has been done, that resumes have been accurately evaluated, and that the company found that there were no minimally qualified workers, at least American workers, that are qualified for the position. And one very important point, as we'll see as we go on, is that this relates very closely to a particular metropolitan area. For instance, the recruitment is done in a particular area, which typically means that it would be invalid if the company moved or went to another particular area because the recruitment is done for that particular area. So just a very broad overview. Stage 1 of the immigrant process in the employment category is the PERM, what we just said, test of the labor market, and that's filed with the Department of Labor, DOL. Stage 2 is, while the PERM is the test to make sure that there are no U.S. workers that are qualified, Stage 2 shows that the foreign national is qualified, number 1, and number 2, that the employer has the ability to pay the wage that is dictated in the PERM filing. And this is filed with USCIS, U.S. Immigration and Citizen Services. And then Stage 3 is the final stage, which can be done in 2 ways, either by the I-485 adjustment of status application, which really tests whether the person is admissible to become a U.S. permanent resident, to have a criminal record, immigration violations, medical, a bunch of other different tests. Or the same thing can be done if the applicant is abroad through consular processing. The I-485 adjustment is done with USCIS, and then the consular processing is done with the Department of State abroad. So really, what are the employer's obligations in regard to PERM? And there are 2 major ones, and especially the first one is divided into many different permutations. But the real 2 employer obligations is, number 1, to conduct good faith recruitment and be truthful in all attestations. That's really the basis of the PERM. And then the second obligation for the employer is to retain documents of the PERM for a certain period of time, as we'll see in a minute. So in terms of the attestations, this is really the major focus of all the enforcement action relating to PERM. PERM is based on attestation. It's not based on a filing like in most USCIS filings, where you present documents to prove your claim, make a claim, and present documents to prove your claim. The PERM is done very differently. You make attestations without any supporting documents. The PERM is in fact done completely online. There are no supporting documents. Everything is done online, and nothing is provided. Nothing is uploaded. Just attestations that you make. And because of that, the Department of Labor, DLO, is very exacting on making sure that that your attestations are accurate and making you pay if, for instance, anything is inaccurate, even if it's not your fault. There's some exceptions, but that's the basic premise of the attestations. Just to give you an idea of what the Department of Labor thinks on maintaining the integrity of the program, they thought managing the PERM process and the integrity, i.e. based on the attestations, is one of the top 11 management challenges facing the Department of Labor. I'm not sure how they got to top 11, mostly top 10, but this was the top 11. And if you think that the Department of Labor doesn't only deal with immigration is probably one of the smallest components of the Department of Labor's mandate. The fact that this PERM process was in the top 11 does tell about what DOL thinks in terms of its challenges and the importance of maintaining integrity of this program. Okay, so just some common examples of some duties that come about in the PERM. Really, you have to take recruitment seriously. It's not supposed to be a joke. It's not considered a game. You're supposed to make or place recruitment in a forum that's best suited to produce results. You are required to look for U.S. workers that are minimally qualified, and that has to be a real process. It's not a game of finding which are the best recruitment forums that will be least likely to provide resumes or qualified resumes. Similarly, there's the employee duties, good faith duties when reviewing resumes. You've got to look at them honestly. You can't say, well, here's a resume, you really got to look at it thoroughly and make sure the person doesn't qualify based on all the requirements that were listed in the PERM application. One current example is use of what we call the Kellogg language, is that if you have alternative requirements for a position, for instance, the position requires a master's degree plus 2 years of experience, or a bachelor's degree plus 4 years of experience, then you have to put special language that any combination of education, experience, and training will be accepted by the employee if they meet what the employee is looking for. And we've seen a lot of PERM audits where they've actually looked at this and said that this is not just language that needs to be put in the application. This is actually language that you need to consider when reviewing the resumes. Just going on, disclosing family relationships. If the applicant has some sort of family relationship to the owner of the company, that needs to be disclosed. May have negative effects on the PERM, but obviously that's a good faith requirement, attestation that you have to make. Similarly, ownership interests with the employee. In other words, if the employee has some sort of ownership interest in the company, the employee has to avoid what's called excessive minimum requirements for the position. In other words, not tailoring the minimum requirements that only the foreign national could qualify. For instance, if you have a position for an accountant and you want, that the foreign national comes from Hungary, and you put a requirement that must have, a foreign language certification in Hungarian. Obviously, that doesn't make sense, and the Department of Labor could challenge that, and usually do. Payment of the PERM cost, there's particular regulations that the legal fees have to be paid by the employer. The attorney role in the process, that's also being challenged. Can they evaluate resumes? What can the attorney do? Some employers just want to give the attorney the file and say, here's the PERM, do it, and they don't want to be involved in the minimum requirements. They don't want to be involved in placing the recruitment. They don't want to be involved in looking at the resumes, and they're just prepared to make the attestations possible. And obviously, that would be in contradiction to a good faith recruitment process. So just note that the obligation continues. It's not even after the PERM is approved or certified that until the adjustment of status is completed. These are the kind of these are the kind of questions that, that typically come up. Look at these kind of examples. What happens if the employer moves? As we said that, the PERM is very closely related to the place of employment. What happens if the employer moves in the middle of the recruitment, but we haven't filed the PERM yet, or if the PERM's pending and the employer moves, or if the PERM's approved but the I-140 is not yet filed, how do you file it, with what address? Or if and it just goes on, I-140 is approved but the I-45 is not filed or pending, or the I-45 is pending for more than 180 days. What happens if it's in the same, if the employers move to a different metropolitan area, statistical area, or what happens if it's the same? All these kind of questions, impinge on the good faith of the owner, and it will have potential negative effects on the PERM. But obviously, the Department of Labor and later in these kind of cases, immigration, the USCIS and the Department of State will, this will impinge on their area as well, and they will expect the good faith to continue. Similarly, employers merged or is acquired during the process, or what happens if you have a long backlog and is a material change in job duties, or reduced, or the foreign national salary needs to be reduced. Another issue is the prospective nature of the PERM. The PERM position is really for a position that's in the future, not necessarily a position that the applicant or the employee is currently holding. So if it's a temporary change that's going to be changed back when the PERM is approved, that may be permissible. Permanent changes, obviously run in contradiction to what the PERM job is, and we have to check that. Generally, non-material changes, standard promotions, or career trajectories, particularly if you go from, say, software engineer 1 to software engineer 2, these kind of things do not impinge on, on good faith on changing. They're just considered non-material changes. Okay, so going to the next obligation, really the retention of documents. So copies of the PERM applications filed with the Department of Labor and all supporting documents must be retained by the employer for 5 years from the date of filing. Note that this obligation is only on the employer, it's on the foreign national, it's not on the attorney. Hopefully the attorney would, if they have some of the documentation, will keep it in accordance with any bar laws, but this obligation is squarely on the employer. And what really, as we said, the PERM is really an attestation-based application, but an audit, or what's called supervised recruitment, we'll see what that is in a little bit, can happen at any time, and at that point the DOL will give you a very, very short time to respond. And what they expect is that you have all your documents assembled and on hand when you file, even though you're not asked for it. So that is just one thing you want to keep in mind. No particular method of retention is mandated, but really the employer will have the burden really to establish that the documentation has been retained. Could be electronic, it could be physical. It's really the employer preference as long as it is maintained. Okay, so over here you'll see the list of the documents to retain. I don't want to go into it in too much detail, but it's a prevailing wage determination that needs to be obtained from DOL, all the advertising and recruitment activities, tier sheets, etc. Notice of postings, notice to unions. This is required either or is generally required in a PERM application. Evidence of business necessity if some of the requirements may be abnormal to what the Department of Labor considers normal to the position. So some sort of explanation or proof backing that up. Recruitment reports explaining how many resumes were received and how many resumes were not received, how many resumes met the minimum requirements or didn't meet the minimum requirements. Hopefully at 0 if you filed the PERM. Evidence to contact potentially qualified applicants. Evidence of resumes received and detailed reasons for rejection. That could be part of the recruitment report, or at least addendum to that. And then anything else that relates to any correspondence between DOL. So going on to the actual enforcement part of the PERM, there are two types of enforcement. The first one is what we call fraud and willful misrepresentation. Actually, when someone intentionally tries to fraud either the Department of Labor or one of the subsequent agencies in one of the future applications. remember that we said, this is only, PERM is only based on how good the attestations are, because there's no documents that's typically filed with the Department of Labor, unless it's some sort of audit or supervised recruitment. So fraud and willful misrepresentation, that's the major thrust of all the enforcement activities. And then, the integrity of the PERM program, as we discussed, is the other. In other words, enforcement is maintained through, a very exacting standard expected of employers. So honest errors, depends what they are. Recently, BOLCA, which deals with, many of the appeals for the PERM process, if something's really honest and really, not very serious, or not very, it doesn't really make too much a difference on the form, it's an obvious error, then there may be options to rely on honest errors, but generally you want to make sure that this exacting process is completed as painstakingly as possible, because even typos, anything that's just really, really what you would think is innocuous can, can be denied by the Department of Labor, seriously, based on, the fact that they, it's attestations and they expect you to be exact because of that. So there are two types of enforcement tools, what we call soft enforcement tools and what we call hard enforcement tools. Soft enforcement tools are really things like denial, audit, and supervised recruitment. Hard enforcement tools are investigations, revocations and invalidations, criminal indictments in appropriate cases, and disbarments. Just note that PERM violations are also always linked with, well, not always, but very often linked with a lot of other different types of laws. If you, for instance, you're paying less than the required wage, and it might also, impinge on fair labor standards and other types of laws as well, especially in employment laws. So, as we said, soft enforcement techniques, they're not really enforcement in a sense, but they really are like penalties, denials, for instance, audits, which are, they really like requests for evidence from immigration. What they do is, it could even be random or for some trigger. They will expect they will expect on a very short notice the employer to provide documents to support the attestations that they made. Supervised recruitment in appropriate cases. Even once you've done your own recruitment and you've had an audit, you can still get supervised recruitment. And what will happen is DOL, Department of Labor, will pretty much say they don't they don't really trust the recruitment that you've done. What they want to do is they'll tell you exactly where to put adverts, and they'll give you the text, and then they'll tell you that all resumes must go directly to them. They'll send they'll send them directly to the employer, and then they'll evaluate the employer's response to them. If this was a real valid way to disqualify potentially qualified candidates. In fact, supervised recruitment can even go up to 2 years from the determination. So right now, around about a third of all PERM filings are either audited or subject to supervised recruitment. So just beware of that. They cause major delays, and obviously they're much higher risks of denial. Hard enforcement techniques. So when the PERM process was being instituted, some people suggested that there should be considered a certain amount of unavoidable fraud. For instance, the IRS, Social Security, realized that whatever they do, there's going to be a certain percentage of fraud, and in some senses they live with it. DL rejected that they would ever do that, and there's no such thing as unavoidable fraud, and they will be very, very they'll be very concentrated on making sure that this that zero fraud is in their program. So in 2008, the Fraud and Detection and Prevention Unit was established. What these employees do, these DOL employees do, they actually do data mining techniques. We'll see in a little bit what kind, to identify and investigate appropriate violations. And then what they do is instead of investigating and then coming to your office and investigating, what they'll do is they data mine certain things, and then they provide information to the certifying officer or to the appropriate investigating unit in order so that they can use that information. So just beware of the following. Social media, officers are on Facebook and they're on LinkedIn and they look at that and they just want to make sure things are consistent. Make sure that the employment is consistent with what you put on the application. If there are inconsistencies, it's possible that DOL is going to know about it. Also, they look at high-profile companies. If something's in the news, a certain company had major layoffs or certain sectors had major layoffs, for instance. The officers will look at that, and they'll put that into the adjudication. They will send it to the officer, or even officers themselves can take notice of that. If it's a strike and that's publicized, that that's something else that DOL is going to be aware of, and then always remember disgruntled employees. If an employee believes that they didn't get the promotion based on this PERM advert, then it's always opportunity, a chance, that the possibility that what will happen is they will make a report that will result in an investigation. So in terms of investigations, if DOL learns that an employer, attorney, or agent is involved in a possible fraud, so that, it's not a very high standard. Even mere suspicion is sufficient. So fraud or willful misrepresentation, kind of the same thing. It can refer the matter to the Department of Justice, Department of Homeland Security, or other government entities, whatever is appropriate. Revocations, DOL can revoke an approved labor certification if it finds that the certification was not justified. It can be revoked even for errors. And then what they'll do is even if it's already approved, they'll send it on to USCIS or Department of State as appropriate. Similarly, USCIS or Department of State will send it on to Department of Labor if they find something that they find is inappropriate. Suspension, if there's some sort of suspicion of fraud or some sort of investigation that's going on, then what will happen is they will suspend the labor certification, even if it's in midair, so to speak, and until that investigation there's a finding of that investigation. So obviously if it's cleared up, no problem, but the suspension will end. But if there's a finding of fraud, the suspension will also end, and then that finding of fraud will be taken into the merits of the application. Criminal indictment, it is a federal crime to knowingly and willfully with intent falsify information. In a PERM, it can be punished up to 5 years in imprisonment or a fine, and that's actually per application. That's per case. Anyone that helps, aids or bets, any accessory to the above offense can also be subject to criminal indictment. And remember, HR, anybody who might know of information, you have to be aware of this, and just note as well that this can also be criminal indictment under U.S. immigration document fraud and perjury provisions as well. And you can look at some recent examples. Somebody in Connecticut, $250,000 in fines for falsifying employment letters. 27 people for fabricating 25,000 applications as well. These do happen from time to time, so just be aware of that. And then finally, the debarment for anybody, it's considered a serious and extraordinary measure by DOL. Debarment is really a ban on the employer, attorney, or agent, not really the employee, but the employee also does bear the brunt of these kind of debarments. And this is for sale or barter or purchase of a PERM permit, especially in the old regulations where you could substitute much easier. The PERM is not a commercial activity. It's not a commercial commodity. So similarly, if you look any also type of falsifying of documents, failure to comply with the terms of the PERM, even if not intentional, if it's continued, that's also sufficient for debarment. And then not responding to audits or supervised recruitment similarly can result in debarment. Debarment no later than 6 years after the filing or the pattern, if that was used. Debarment can only be for 3 years. and then all the departments are published on the DOL website, so everybody will know who you are. And then just note that DOL will also notify Immigration, Department of State, and others, as necessary, and that can result in I-140s and I-45s, H-1Bs, LCAs, I-9s, all other types of investigations. There is an appeal process, and debarment is stayed until the final decision, so you do have some time once that is done. And that pretty much ends. I don't know if we have enough time for questions, but I'll put this over to Joseph, who can address that.
Okay, so I will take a look at and see what questions we have, and even if we don't get to all of them or any of them by the end of this presentation, we will respond to you via email with your question. I do want to add one note of this just in. During our presentation, the American Immigration Lawyers Association put out the notes from its meeting with USCIS HQ, and one important and timely topic was confirmed by USCIS for the first time in a while. Previously, it was unknown whether or not you had to file an amended petition with USCIS when you changed the worksite location of a worker within the same metropolitan statistical area. It's been a gray area where employers and attorneys are insisting that no amended petition is necessary, but the fraud FDNS site inspectors and USCIS insist that it was. Now we have confirmation that a change in the place of employment by a beneficiary to a location in the same MSA as listed on the controlling LCA as certified with DHS with respect to that beneficiary alone is not a material change in the terms and conditions of employment, and therefore would not require filing an amended H-1B petition. So that is fantastic news all around. We are out of time, unfortunately, but I do have several questions here from individuals, and I will follow up via email in answer to your question. Thank you all very much for attending this webinar. It's been a pleasure, and if you have any other questions or want to follow up with more information or request more information, please feel free to contact either Cliff or I, Joseph Shepard and Cliff Rosenthal. And Cliff, that's it. I think we're all set.